This video will discuss key insights which you need to know before going to the tax court of Canada. If you disagree with the way the taxman has assessed your return, the first step you need to take is to file a notice of objection and attempt to have the decision reviewed by the CRA appeals officers. I did a video on the details which you can see on the screen's top right, but this video has a focus on the tax court of Canada. You see, when submissions to the appeal officers are unsuccessful, the only recourse left for you is to appeal to the tax court of Canada. The tax court stage of a tax dispute is undoubtedly a big step up from the internal appeals process of the Canada Revenue Agency, as there are many more formalities and procedures that you will need to observe. You see, most taxpayers never have a reason to go to the tax court. Going to the tax court may be intimidating because the other party in this case is the mighty Canada Revenue Agency. Now you might ask, what is a tax court? Well, the tax court of Canada is a specialized court in Canada that has exclusive jurisdiction over legal tax matters. The tax court is the body of court to handle all tax court appeals and tax reviews. Often cases in tax court can be settled short of going to trial, given the fresh look the Department of Justice will give to each file. But let's say you, your CPA and your lawyer think that you are correct in your position and CRA absolutely refuses to agree with you, then you have the ultimate recourse of having your day in the court. If you go for a trial and need a representative, you will need a tax lawyer who will introduce evidence documents, witnesses, and then the Crown will do the same, and there will be a legal arguments in the court, and the judge will then render a decision. Essentially, the tax court judge is capable of applying the law as written in the Income Tax Act as interpreted by the binding authority of more senior courts. The tax court has 3 powers granted to it with respect to the appeals of assessments and reassessments. The tax court of Canada judge may confirm the assessment or reassessment issued by the CRA, or the Canada tax court judge can vacate the assessment, ordering the CRA to reconsider the decision and issue a reassessment to the taxpayer, or the tax judge may also direct the minister to reassess the taxpayer in accordance with his or her instruction based on the findings of the fact determined at trial. But going to court can be expensive, and even more so if you are ultimately unsuccessful. Parties who are involved in the tax disputes in either the tax court or the federal court of appeal always have to be wary that if you lose, you could be hit with costs. So cost-benefit analysis is required, weighing the prospects of success against the amount of tax in dispute. So consult your chartered professional accountant and a tax lawyer before taking on the taxman. The added benefit is that a lawyer-accountant collaboration means that all of your accountant's work may be able to be cloaked with solicitor-client privilege and thus become immune from compulsion and seizure by the Canada Revenue Agency. Thanks for watching this video and see you in my next video. If you want to be notified about my new tax updates, please consider subscribing to my YouTube channel.